Hi, and welcome to another interesting topic on this podcast. And today we take our interesting topic, which is on criminal convictions from US, Canada, and an HR perspective. That sounds so weird. Where did the HR come in criminal convictions? But here we are. We'll take a deep dive on this topic and how it's relevant from immigration standpoint between US and Canada, and also from the human resources standpoint. So, with immigration law, it's increasingly becoming and intersecting with criminal law, giving rise to a field called crimmigration. Any interface with criminal charges affects the immigration status of the individual. These could also affect if you're a citizen of US or Canada and you're traveling across borders. From human resources standpoint, it may be a generic understanding that an employee is obliged to inform the employer of any new or prior criminal convictions to the human resource department. To shine light on this topic, we welcome Leona Wilson, President, Armillary Business Group here in Mississauga, Ontario. She brings with her years of experience in the HR, representing entities up to 600 employees across Canada. Hello and welcome, Leona.
Hello, how are you today?
Very good. And here we are with the HR and criminal convictions. So let's begin our first question on, are there any different types of criminal record checks and how does this impact recruitment?
In actual fact, there are 4 levels of police record checks. When we're looking in the employment context, it's generally 2 types that we are looking at. The level 1, which is considered a criminal record check. This is the one that's most commonly used in employment. But the secondary one that's quite popular is the level 3, and that's the vulnerable sector check. The vulnerable sector check will be required if an individual is going to be providing services to children or to individuals who are considered vulnerable, for instance, in-aged or developmentally challenged individuals. So we see this in educational institutions, we'll see it in daycares, we'll see it in music schools, PSWs, healthcare.
Wow, that's wonderful. Very good information out there. But then that just takes me to our next question, that at what stage of the hiring process do employers ask for criminal record check? And what are the best practices?
What I typically have seen is that we're not necessarily going to put that into a posting for a job. We might, for instance, indicate that the individual needs to be available to travel if it is a criteria for that particular role. And best practices would be, of course, to share out where that travel is going to be in the hopes that an individual will self-select themselves out and not apply for the job. Typically, what I advise my clients to do is when we're actually shortlisting candidates, that we're actually getting ready to do the interviews or to put in screening questions, if we're using AI as part of the process, that at that point, we're going to indicate that part of the process requires a successful criminal records check or a vulnerable sector check, depending on the nature of the job. But it's important for us to know that it depends on what the position is. Companies generally don't require this of everybody who is working for them. It's really specific to the role itself.
That's very interesting. And then that just helps me understand. We had a client who was a flight attendant, and they were obliged, of course, to travel all over the places. And one of this employee had prior criminal convictions. Now, what is their obligation? Because to us as lawyers, he informed us that he has already asked the HR that he will not be going to certain countries. And I'm assuming it's because they are not ETA exempt or visa exempt. So he's already placed that on the HR. So if the employee tells you or provides any of this kind of information that these are not the countries he wants to travel, is that something you would dig deep into it or just leave it out there?
I think it really depends on the organization and how they actually do their scheduling. You know, that's a very specific situation. But nowadays, post-pandemic, many companies are not doing the level of business travel that they were doing before. It might be possible to just deal with Zoom calls and conduct business in that way. It will, again, depend on the job position itself and whether or not it's a requirement. For instance, if the company has a corporate head office that's in one of these countries where the individual is not going to be able to go and cross over to the border, I think that's going to be something that's going to be a little bit more significant. But that is something that should be established during the intake process. And of course, there's always possibilities that the business might end up changing their business model. They might have new clients, so now there might be some new requirements that are happening. And then that other point that comes up as well, what is the process of the employer to continually review these crim checks? What I see so often is that companies will perhaps do the criminal records check when the person is recruited and never touch it again. So I'm always advising my clients to have an attestation process year over year that nothing has changed, and to go ahead and canvass a fresh criminal records check. There are some industries where a fresh criminal records check is required every 6 months. So it really depends on the criticality of this point to the person's position and the industry and the standards that are in place for risk mitigation.
That's very interesting to know. And I think that's a good practice where the employer does that annually or periodically. Maybe some employees have been working for last maybe 5 years, 10, 20 plus years. And it's always good to go back and check that, hey, has anything changed? And especially, as you mentioned, if the headquarters are outside Canada, it becomes all the more prudent for the employer to do that continuous background check periodically. And then, are there any other advices that you would like to give to the employers who are hiring and with regards to the criminal record?
I think it's important to set up some policies within the organization for what are you going to do if a criminal record appears in a screening process. In some organizations, absolutely nothing can be showing up on a criminal records check. For some other employers, there's a little bit more flexibility, and I've certainly seen this. You know, when we consider criminal issues, it's either a property issue or it's something towards a person, and usually there's going to be a little bit of a thoughtful conversation around, is this really going to be a problem? If somebody, for instance, is going to be working in an office environment, they're not in the transportation sector, they're never going to have to drive. And 15 years ago, there was a driving under the influence charge. You know, is that really a material breach that should impact the individual's ability to do their job? I would say no. But again, it depends on the company's policies. It also depends on any service level agreements that they have with their clients as well. I think it's important to consider that not everything that shows up on a record should necessarily, you know, lead to a loss of employment or you know, being no longer considered for a role. That seems to me like it's a little too punitive. But again, it's very dependent upon the organization and their risk management. But the most important thing is to have a process in place to continually review. If it's important to ask for it at the time that you're hiring the person, it should be important to continue to ask for it and not have it be one and done, which is what I typically see.
That's very interesting. It should not be rightfully set against or have any prejudice against the employment opportunities. But again, it becomes very sensitive and very critical also as and when the employee grows up the ladder in their employment path with the company. Now, with having said that, I'm going to shift our gaze towards US, and I'm going to ask our guest here. Welcome, David. Welcome to this podcast. And
thank you so much, Gagan. Thank you for the invitation. It's nice to be with both of you.
It's always a pleasure, David. And it's very interesting, as Leona mentioned, that there are certain companies that would be present outside Canada. And what if their headquarters are in US? And these employees, and when I say employees, I would mention Canadian citizens, permanent residents, or any foreign national. Maybe they're working under an intra-company transfer here in Canada. What are their obligations when they are traveling into the US with any prior criminal convictions, whether they happened inside Canada or outside Canada, maybe in their home country? Over to you, David.
Yeah, so that's I guess I have to unpack a very big question there, because it really has to do with, I think, the level of criminality in the US. So, for example, we have certain types of crimes that are considered to be de minimis. De minimis means that, it's a small penalty or jail time of less than 6 months, something which is, not necessarily material, or a basis for inadmissibility. But then we get into things like crimes of moral turpitude, which are more difficult to deal with because they're subject to interpretation. Then, of course, we have, levels of crimes that are much more difficult to deal with, which are felonies. So, it really depends upon the level of the crime and whether or not a waiver is required. In some cases, if an individual is seeking a non-immigrant entry into the U.S., then there are waivers that are permissible under 212D3. Those are applications to the ARO. The problem, unfortunately, with those is they take a very, very long time. And then, depending again upon the level of criminality, whether or not there are complete bars to just the individual's completely inadmissible. But before I go any further with that, I think it's great that you got someone who's in HR together with us to talk about this, because this is an area which also, I think, from the ethical standpoint, it really raises a lot of really interesting ethical rules or issues. And, I'd be interested in, Leona was talking about recruitment of an individual and how to deal with criminality in the recruitment arena. But what happens, and, we deal with this all the time, is that the immigration process is designed where the employer handles half, and then the rest of it is the individual is responsible for. And I really liked your explanation, Leona, about how it's not just like a one out, you continue to check. But what happens, let's say, when you've brought someone on and they've made representations that there's not a criminal issue, and then later on you find out that there is. And sometimes that happens, like in the immigration arena, where, for example, we'll be doing a matter where we'll be working with HR, and HR will get us to do the whole process. And then all of a sudden, the adjustment of status process, which belongs to the individual, they say, don't tell my HR, but I had this issue. And then all of a sudden we're like, well, what do we do? How do we deal with that? Because do we have an obligation to tell HR that this individual has this criminality issue that has to be dealt with? So it raises some really interesting ethical issues. And I'm not sure whether we're going to be able to get into that too deeply, but I just that came to my mind when Leona was describing, how she was doing the recruitment process in criminality.
Now, that's an interesting one. And the way we take it in Canada, as a lawyer, who am I representing? Am I representing the employee or the employer? That would be my start point of knowing that no, there's no confidentiality, and that's how our retainer agreements are laid out, that any information shared between any of with the employees will be shared with the employer, because employer is my client and I cannot withhold that information again on these ethical grounds. And do you want to add anything else, Leona, to this?
No, there really shouldn't be any surprises. If we're doing an offer of employment and it's conditional upon that criminal records check, we're going to have the information before everything is finalized. We really can't ask for that criminal records check until we've actually given an offer of employment. So for us, I don't think it's going to come up in quite the same way as maybe David has presented and as David has experienced.
Back to you, David. So let us know also your thoughts on, as you were mentioning and describing about waiver, if a Canadian citizen is a truck driver and they are obliged to come too often, drive frequently to Canada, what are their obligations? And especially when you've mentioned that it takes way too long for these kind of applications to get adjudicated. So what is their path if they decide to come to US?
Well, again, I think that if they're going to be coming to the US and they have issues of criminality, the best thing, of course, is to seek legal guidance from an immigration attorney who is not just an immigration lawyer. I usually tell them to seek advice from an immigration lawyer who also has criminal background, if they can. So we call that, and I think you referred to it, Gagan, earlier as a crimigation lawyer. So it's very, very important to get the appropriate guidance before you travel, because what you don't want to do is find yourself coming to the port of entry and then being inadmissible, because then you could potentially be barred for numerous years. And and I think the other thing is that we have to help, I think, the listeners understand the distinction between getting waivers for non-immigrant visas, which is 212D3 or 212H, and then you also have waivers for the lawful permanent residence. So if a person is seeking a green card, then they have to get it using the I-601, which requires that they have a qualifying relative and can prove extreme and unusual hardship. So those are sort of the bases for being able to get those types of waivers. But I think if an individual has issues of criminality, again, they just have to be able to obtain the right advice from someone who's familiar with this type of a process.
Thanks, David. And then I was just curious also to know about, is this the process also for anybody applying for spousal applications? They still have to apply for waivers, or is it just something specific when they're applying for employment-based applications?
No, that's it also applies in the family-based context. So individuals who are applying for, and again, I think it depends upon whether your question, I think, goes to the second part of what I was saying, which is that in the family context where you're, let's say, doing a lawful permanent resident green card for an immediate relative, then you're looking at doing an I-601, which again requires first that you have a qualifying relative, and in that context, the qualifying relative is the spouse. So that works, you have that. And then the challenge, of course, is to prove the extreme and unusual hardship. And that oftentimes we'll do based upon financial issues, based upon psychological issues, based upon, oftentimes what we'll do is we'll engage a psychological professional, a social worker or so on, who will be able to opine on the hardship that would be thrust upon the U.S. citizen as a result of the individual being unable to enter the United States.
Wow, perfect. I know the answer on the Canadian side, but I'm very curious to know on the US side that if someone traveled by air, and a lot of my clients, they say that, okay, we traveled by air and we are US citizens and we are visa exempt when entering Canada, and nobody even questioned our prior convictions. I had a DUI 20 years ago, but the officer never even bothered asking. I had a clean pass. I know on Canadian side, you have an obligation to inform the officer. It is your own duty to inform and tell them that this is what you've had in the past. What about US? If any Canadian citizen entering US by air, and do they also encounter similar situation where the officer may not be able to find out just by swiping their passport, etc., and they could enter US easily?
Yeah, it's a really interesting question, Gagan, because then what ends up happening is you're into an area where, when a person is coming from Canada, they're entering as a visitor and they don't have to fill out a DS-160 form, which asks about criminality or, have you ever been arrested, cited, charged? And, so they don't have to answer that. So you're really relying upon what's in that database. And it oftentimes, you know, the one thing that's very interesting is that I find from a technological standpoint is that Canada and US are very much in tune. They're, you know, when they search the database, the data share between Canada and the US is just tremendous. More so than a lot of countries. I think the UK and the US and Canada and the US is almost, you know, almost on par, but it's at such a higher level compared to other countries. And I think that's also one of the reasons why, you know, the recent travel ban was put in place from the United States, because President Trump was saying, well, you know, these other countries are not sharing information with us. So how do we know? And that was actually put in place to force those other countries to get to that level, like Canada and the UK are with the United States technologically. But going back to your, I'm sorry, that was a little bit of a detour, but getting back to your question is that, yeah, I mean, I tell clients, look, you know, when you're, you don't have to tell the government information that is going to hurt you, okay? But, I mean, subsumed within the admissions process, as most people know, is that, you know, you're supposed to obviously, if you're asked about it, you have to tell the truth. You have to say, so if they ask about it, you have to tell the truth. But at the end of the day, I think really what it relies upon is what's in that database. And you hope that the officers, if there is an issue of criminality, the officer should be able to pick that up and then make the inquiry of the applicant.
Awesome. That's very interesting and a little different from our side of the world. And I agree with the information sharing, especially starting January this year. We had another amendment in Canada, and now any and all information about foreign nationals, their biometric information, is everything is shared between with US completely. So there's more transparency, more information sharing now than before, and it's just getting more and more stronger, more transparent and clearer out there. I'll now just go over some of the nuances that we have in Canada in place, and please feel free to interrupt or ask questions. If anybody has prior convictions outside Canada, and those could be, there's a list of questions that are provided, a list of offenses that are provided in, which includes theft. It includes dangerous driving while under the influence of drugs or alcohol, possession of or trafficking of drugs or controlled substances, assault, manslaughter, etc. These are the offenses that the government has laid down, that the Immigration Act has laid down, that if you've had any of these convictions, prior records, then you cannot just enter Canada. You either require a criminal rehab application to be done or a temporary resident permit. Now, if these convictions have been as recent as within last 5 years, then you will be applying for temporary resident permit, but give the government enough reasons for you to enter Canada. That could be your work reasons or meeting your family, etc. And you have to apply for this kind of application before entering Canada. Earlier, it was very easy. I would say not easy, but yes, if you had your solid application prepared, a TRP package was prepared well in advance, you take it to the border. And even if you were coming to for just generally visiting your friends, or for even ice skating, or even for some winter holidays, you could still enter and provide that TRP package, which would have the FBI record, which would have the police clearance from your state. The officer would be liberal enough to allow you to enter Canada. Not anymore. There's a huge pushback, so you have to apply online before you make that trip. Another part is criminal rehabilitation, and which literally means that you the offense has occurred more than 5 years ago. You have rehabilitated yourself, your lifestyle has changed, and now the occurrence that happened, you feel very remorse about it. So you prepare your application on a rehab application and submit to the government. IRCC is going to look through all the documents documents, see how you have evolved personally, professionally, and have you connected with the community, etc. And then they would, if they are convinced, that would take away that would remove all your inadmissibility into Canada, and you'll be allowed to enter without any issues. So I encounter this question all the time, that why do I need to inform the government? I can simply travel by air and nobody is even going to check my passport. So, and I had this interesting question actually coming from a flight attendant, and then I had to go back and tell them that, look, it's your duty to inform the government. You are under the obligation, and if you are found guilty of not informing, it could end up into a misrepresentation which has serious bars, and you would not be able to enter for next 10 years or 5 years. So it's better that you inform the government and go through proper process than they finding and asking you questions. That's what I tell my clients all the time. It's better to inform them rather than they sending a letter to you and asking what happened. Why was this information withheld, or why did you enter knowingly that you have an offense out there in the past? So this is how we play around between US and Canada. If there are criminal convictions, you got to be transparent, you got to be upfront and informing the government. And and again, this is such an interesting topic where the same convictions could be held differently from the US standpoint, from Canadian standpoint, and most importantly, from the HR standpoint.
Thank you. It's very interesting to hear the US perspective on things. This is something I'm not so exposed to, but definitely we need to be transparent with our teams, and our teams need to be transparent with us. To your point, it's never a good thing if we find out. It's much better if the employee comes to us, then we can work with them. If we find out on our own, then it's as though the individual has been deceptive with us, and that really damages the trust in the relationship. So best to be upfront. In Canada, just to highlight another statistics, roughly 10% of all adults have a criminal offense of some sort. So it's quite common, surprisingly. So this is something that we encounter fairly often. But again, it depends on the individual's role. Many positions don't require that level of oversight.
Interesting.
David,
ladies, I want to commend you on the subject matter and the clear cross-fertilization between the cross-border as well as going into HR, and how it also overlays with the immigration, because this could be easily a full-day topic that we could talk about. But so I really commend you for bringing this to the attention of your viewers. There are just a couple of things I want to quickly hit, and that is that and I was just jotting them down as you were speaking. Number one is that, criminality in the United States is based on the state, whereas immigration is a national law. So, when you're charged in a state with something, what we have to do is almost like a comparison. We have to compare that charge to what it would be, in the immigration regulation. So it's a kind of a cross analysis that we have to do. And each state is different, which is oftentimes why if somebody calls me and says, oh, well, so-and-so was charged in North Dakota, I have to say, well, I can't really opine on that because I'm not a lawyer in North Dakota. You have to go get a North Dakota lawyer, and we can work with him on the immigration side to try to figure out what that North Dakota charge or conviction is and how that compares to what would be deemed to be, let's say, either de minimis or a crime of moral turpitude, as it's understood under the federal statutes. So it's really an interesting puzzle that we put together. Finally, I just want to mention one thing which is very confusing to everyone, and that is marijuana. Marijuana is a really difficult one in the United States because, it's legal in many states, but it's illegal from a federal standpoint. So people who, let's say truck drivers who might be coming in are thinking, oh, well, I'm just going to the state of North Dakota. But from a federal standpoint, they're going through a federal checkpoint and that's illegal. So bringing marijuana into the United States is illegal from a federal standpoint, but it could be legal in the state that they might be entering. So it presents very, very interesting challenges. And I'm sure that Leona, can probably spend the day talking about marijuana in the workplace, which again is another very interesting topic that HR has chatted about recently. So, but thank you very much for the invitation today. It was just wonderful joining you, ladies.
You're very welcome, David, and we look forward more. And especially now you've given us some ideas about what else can we touch upon with marijuana, immigration, and criminal law. Yes, that's very interesting. And again, from a Canadian standpoint, yes, a very conservative lawyer, I would rather do it the right way. And in fact, one of my clients that had a pending criminal rehab application, which usually takes about 9 to 12 months. So during the time the application was pending, my client just decided to travel to Canada, and he had prior TRPs. So it wasn't an issue. He picked up his TRP, but then he said it was Christmas Eve and nobody stopped, and he was just hushed out of the checkpoint, and he never even showed the officer about the TRP package. I said, no, it cannot be this way at all. You have to go back, inform that this was a misunderstanding or this was your innocent mistake. Although Canada does not take innocent mistakes lightly as well, and there is still a misrepresentation that's under 40A of the Immigration Act. So I just asked the client to do it the right way. He got his rehab approved, traveling between US and Canada easily. So my advice always to our clients, to our listeners, is that do it the right way. There are options. We can always think of the options rather than hiding, withdrawing, and doing all the sideline acts. Then it's very difficult to find what the right path is, and who knows, you might end up in removal orders, or it could be much bigger, nastier, or messier situation. But again, wrapping up this podcast, thank you so much to our wonderful guests, Leona and David. We look forward to discussing more topics going forward. And thank you again. Have a good rest of your days.
Thank you so very much.
Thank you.